response to the state's response is guilty. So let's just start from the top. It is the state's motion. So if you want to urge them.
Your Honor, it is the state's response.
State's motion to exclude defense testimony.
Sure, Your Honor. And the state did file, as the court just noted, a lengthy response with much law included. Procedurally, for the record, the parties were in Davidson County on the 8th and the 9th of last week to choose a jury. Mr. Chen had been transported on January 6th to the Davidson County Jail. Jury selection began promptly on the 8th and ended in the late afternoon of the 9th. The court did inform the parties that court would be closed on January the 10th due to inclement weather. Friday, January the 10th, all parties, including Mr. Chen, were back in Hamilton County, and at approximately 2:15, the state received notice from Mr. Weiss, the defendant's attorney, that they were giving notice to the state that they intended to introduce expert testimony regarding the defendant's mental condition, presumably at the time of the offense in 2022. Of course, this caused concern for the state for many reasons, primarily the timeliness and the violation of Rule 12.2b in terms of notice of a defendant's mental condition. The state asked for a phone conversation with all parties on Friday. Type of hearing or discovery or meeting with the parties. It is significant to note that Mr. Moyle and I, General Moyle and I, have met with Ms. Morris and Mr. Weiss multiple times throughout the last several months to exchange even undiscoverable evidence. The state has gone out of its way to provide demonstrable exhibits, PowerPoints. We allowed them to look through our own box account. We've had met them at the police department to review evidence. Never has an expert witness been mentioned, and the defendant's notice did not provide any information as to what mental condition was being alleged or asserted by their expert. The court then ordered informally on that phone call that the defendant basically turn over what was in their possession in regards to the mental condition and any information about the expert. Mind you, the name of the expert was not listed in the notice that was filed at 2:15 on a snow day. And on Friday, later in the day, Mr. Weiss did send a email to General Moyle and I with the expert's name and his curriculum vitae. And I believe in that email it was also notice. It was a letter that signified that while the expert was not licensed as a psychologist in the state of Tennessee, he had (18th, 2024). It was not until approximately 5:30 on Saturday that the state received what is entitled memorandum pertaining to expert testimony. In that memorandum, the psychologist kindly explains and articulates the law to this criminal court, of which 4 attorneys involved in this case and a criminal court judge are acutely aware. And there's one paragraph in that alleged expert's report that has to do with Jason Chen. There is one sentence in that report that states that Mr. Chen was not able that Mr. Chen was unlikely to have possessed the requisite premeditation for the act of criminal homicide. The memorandum never mentions a mental condition. As it stands right this second, the day of trial, the state has no idea what mental condition the defendant is alleging he had on November 23rd, 2022. We don't know if it's an intellectual disability based on the tests that were apparently administered to the defendant, which are attached to the expert's memorandum. Based on those, it would indicate it was some type of intellectual disability, as those are psychological examinations that go to reasoning and critical thinking. We have no idea if it's a mental health disorder such as schizophrenia or bipolar. We had heard on the phone call with Your Honor the words voluntary intoxication. Voluntary intoxication, the word intoxication, the word substance abuse, the word addiction is never in the alleged expert's memorandum. This is the epitome of unfairness, Judge. The state has the right to present rebuttal proof. It's one of the reasons why Rule 12.2 has a timing subsection to it. There is no way, it is not virtually impossible, it is absolutely impossible that the state ever could have searched for or investigated any type of rebuttal proof for an expert that we not only knew, well, we didn't know of, but we still, as of 9:30 on January 13th, have no idea what the expert is going to allege or opine at trial. We were not able to voir dire jurors on whatever mental In fact, if the jury was sitting in the box right now for voir dire, we would have no idea what to voir dire the jury on. We have the right to a fair voir dire. We would have, in fact, asked questions that pertained to some mental disorder, I don't know, still don't know, mental condition, mental health issue, I have no idea, intellectual disability, no clue. We would have, in fact, voir dired on that issue. It would have changed the process of voir dire for us. It would have changed the preparation for trial for the state of Tennessee. Had we known that there was any type of expert witness that has to do with psychology or the defendant's mental condition, we would have an expert witness sitting in the audience right now to hear what this expert has to say if the court allows the expert to testify this morning in any type of deposition or hearing. We would have them here. We weren't able to do that for obvious reasons. We learned the expert's name at the end of the day on Friday the 10th. Saturday and Sunday are not working business days. While the state of Tennessee worked all weekend, a psychologist or psychiatrist in Chattanooga, we couldn't get a hold of them. And while no party in this courthouse should ever underestimate the capabilities of the state of Tennessee, we are not magicians. We can't just come up with a rebuttal expert witness on a mental condition that we are unaware of at 9:30 on January the 13th. This notice was untimely. This notice never would have been able to happen in any other case in Your Honor's court except for a sequestered case done in the manner in which it was done in this case. The state's case in chief. Typically, this would never have even been able to happen, much less allowed. It is in a rare circumstance that Mr. Weiss could have planned to know of an expert in early December. We know that they knew of him on December 7th. because based on an email that they sent to us, it states that he confirmed his availability to meet with the defendant on December 7th. 1 month before he met with the defendant in the Davidson County Jail. They waited. They waited. They knew the week before jury selection that he was going to interview the defendant in the Davidson County Jail. They knew that he had interviewed the defendant in the Davidson County Jail on the 7th. They were in court with Your Honor on the 8th and the 9th. The court repeatedly asked the parties, is there anything that needs to be taken up? Repeatedly. At the end of the day on the 9th. But it was not until 2:15 on January the 10th, after 2 years of preparation on this case, that the defense came up with a mental condition defense. And the defense has argued that it was only after the state provided a demonstrable exhibit to them that they realized that they needed an expert witness that had to do with the defendant's mental condition that affected his ability to form premeditation. Think about this, Judge. Premeditation has been an element in this case since 2022. The Hamilton County Grand Jury indicted Mr. Chen for first-degree premeditated murder. If defense attorneys believed that his mental condition at the time affected his ability to form premeditation, and they waited until January 7th to have an expert evaluate him, then we've got much bigger problems than a timeliness issue. Premeditation has been the case, it has been an element in this case since 2022. And notably, Mr. Weiss represented Mr. Chen in 2022. There has been no counsel substituted. It has been Mr. Weiss since the beginning. The demonstrative exhibit that the defense has such a problem with, as the court has already seen, involves 2 pieces of evidence that have been in the defendant's possession for almost 2 years. A photo from Mr. Chen's apartment of carpet with blood on it, and a photo of Jasmine Pace from the medical examiner's office. The court found in the hearing on this issue that even the state could have superimposed this piece of evidence on this piece of evidence to come up with a demonstrative exhibit. How can a demonstrative exhibit that was given to the parties on December 11th, the day that it was given to the state, even though every party had both photos, but the superimposed photo was given on December the 11th, how is it that that photo affected premeditation in so much as the defense all of a sudden, near or around December 7th, contacted an expert witness? It is untimely, it is unfair, and the state of Tennessee has a right to a fair trial. And the people of the state of Tennessee have a right to a fair trial. We ask the court to exclude any expert testimony at this point in time that was presented to the court and to the state in an untimely fashion, especially that of Mr. Douglas Lewis.
Mr. Weiss's pleadings, he mentions that the demonstrative exhibit seems to indicate that the victim might have been handcuffed in Mr. Chen's apartment. And that's one thing I think he mentions is the problem with the demonstrative exhibit. Could you respond to that?
Sure. Your Honor, the medical examiner issued an autopsy report. The date of examination is 12/1/2022. The autopsy report was given to the parties just within a month or two. Of course, it takes the medical examiner a month or two to finalize an autopsy report. And in that autopsy report, there's a sentence that says, the injury locations are consistent with the decedent
say for sure that the victim's handcuffed while alive might have been received also from fetal position, but not necessarily handcuffed. Is that correct?
I believe that Dr. Cogswell can opine in what position she would have been in when the injuries occurred, and then the jury can therefore, as the trier of fact, make their own conclusions as to the position of her body was only in the fetal position with those type of stab wounds because she had been handcuffed. So the trier of fact can draw their own conclusions, but furthermore, Your Honor, there was a bond hearing in this case in General Sessions Court in which Mr. Weiss represented Mr. Chen, and similar to the autopsy report, Dr. Cogswell testifies the injuries and the concentration are all on the right side. Virtually all of them can be inflicted with her in that bound position. So I believe that there is evidence in the record that would allow Dr. Cogswell to testify that she was in the fetal position. Whether or not he is going to testify that she was, in fact, in those handcuffs, that is for cross-examination. You can obviously cross-examine. That is part of the trial experience. So the defense did have information and evidence in discovery for years that would have indicated that she was in the fetal position. She was in that fetal position because she'd been handcuffed, and the jury
Rule 12.2b2 says, timing. Notice described in 12.2b1 shall be filed within the time provided for filing of pretrial motions or at such later time as the court may direct. The timing to file pretrial motions has not ended. As of right now, without a jury sworn, I could file a pretrial motion right here, right now. This rule does not limit my ability to file a notice right here, right now. This court, and I say this with the utmost respect, could have ordered a scheduling order or a docketing order requiring the parties to have presented certain proofs, certain discoveries, certain evidence, certain motions at this point. The court has never ordered that. The defense is not in violation of the Tennessee Rules of Criminal Procedure, and the defense is in violation of any of the court's orders. So this is not untimely. It is timely. Secondly, Dr. Lewis was contacted about a month ago due to timing of the holidays and him getting authorized to practice psychology here in Tennessee. He was not able to evaluate Jason until January the 7th in Nashville. We weren't able to speak to him about his results. He had to review his results, go over everything, and we didn't get those results until late on January the 8th. As soon as we had those results and we knew that we were going to call him as a witness, that's when we filed the motion on the 9th. And even though the courts were closed, it was obvious that all the parties were aware of it. The General Wamp texted, all the attorneys texted the court, and we had a conversation about it. And the court has ordered that Dr. Lewis submit a memorandum or report, which he did on Saturday. And I don't know what document the state is reading, but the memorandum in the submitted by Dr. Lewis talks about the psychological issue. Diminished capacity. It's right there. We're not alleging that Jason was insane. The state did request a notice for the insanity defense. We're not pleading insanity, so that has no bearing here. We're not saying that he has some type of mental condition. He's not have any type of mental health condition other than what's stated in here. So it is very clear the state has exact notice of what's being alleged by Dr. Lewis. And even if they don't, Dr. Lewis has been ordered to be deposed this morning. He is ready and waiting in the virtual waiting room for the court to admit his testimony. And finally, I find it rich that the state says this is untimely. This court, again, didn't file a scheduling order. That means Rule 16 discovery applies up until the day of. I was given a video from Walgreens that I had never seen before. And when did I receive this video from the state? January the 8th. The state has provided discovery, monumental amount of important discovery in the last 45 days. At no point did this defense seek a continuance for providing this discovery. The state hasn't sought, or the defense hasn't sought to exclude this discovery. The state is asking the lines of an autopsy report. But General Moyle said at the last hearing, and in his own response to this notice, that they are going to allege that Jasmine was shackled while alive and then killed. That is nowhere contained in any discovery, any evidence. We are surprised. We are being ambushed with this same information. And once it came to the realization that they're providing this information to prove their theme, well, then it became necessary to show that Jason doesn't have, or has a condition that would prevented or negated premeditation. And that's what Dr. Lewis's testimony is all about. There is nothing preventing him from testifying at trial. The state is not prejudiced. They'll have full opportunity to depose him. They'll have a full opportunity to voir dire him during trial, and they'll have a full opportunity to cross-examine him during the course of the trial. It's not unfair, and we ask that the court deny their motion to exclude Dr. Lewis. Of course, Judge.
Start with easy. The Walgreens video that you provided recently, in any way unfairly prejudicial to your case to the degree that you're asking for continuance?
No.
While, and I don't like filing scheduling orders, I know when I was practicing that a lot of work does get done as it builds up trials, and so therefore a lot of things have to happen. As long as everyone communicates, I've never had it be a problem. I don't even know if it's a problem today. We're certainly discussing it. But while 12.2, as everyone knows, doesn't necessarily put a specific timeline on it except before trial. This is something that apparently the advisory committee's looked at a lot. In the notes, it's in the case law, it repeatedly refers to unfair surprise. But the state is unfairly surprised. So apparently it's a common practice or common occurrence, I should say, that a lot of times these experts are brought up at the last part of the trial prep. And so that's why there's a lot of case law. And so in this particular case, I'm clear when you asked for funds for an expert in December, it was a wise move. He knows how an expert can help you out with helping you cross-examination or just looking at the case and helping at different angles for sure. It seems like it got rushed at some point when it's almost like when the state allowed or was allowed to use the demonstrative exhibit, that solidified or caused you to need the service that this expert has provided you so far. There's thinking your own notion, how it encapsulates it. We're going to talk about it once defense attorney, you promptly secured an expert who issued court. The link for that is the state discloses the last minute evidence for premeditation less than a month before, despite the case being years. Upon receiving this late disclosure, the defendant promptly secured an expert who issued court. So that's how I'm interpreting that. It's the acceleration came from the hearings in December where we talked about the exhibits and the amount of exhibits deemed to be admissible. Is that a fair assessment?
Yes, sir.
Okay. Thank you.
Your Honor, may I briefly respond to some of that timeline? The defense states that it was only once they learned the theme and theory of the state's theme and theory that they realized that the state was going to allege that she was shackled at the time the injuries occurred. But that timeline actually doesn't work in terms of the timeline of their expert witness, because the meeting that we had with them in which we discussed and went over the demonstrative exhibit was December 13th. The day that they got that demonstrative exhibit was December 11th. Based on email communication and the representation of defense counsel, they confirmed Dr. Lewis's availability on December 7th.
Can I respond to that briefly? Just to make sure.
Yes, Your Honor. Yes, Your Honor.
There are many reasons to retain an expert. When Mr. Wise approached me on it, I wasn't sure exactly how this expert could be used. It might be just for consultation. It might be for sitting in court for cross-examination. And so I don't really hold that against Mr. Wise as far as retaining an expert. It seems that the purpose for which this expert is being offered now seems to be being accelerated with the demonstrative exhibit issue. That's not my interpretation, but if you want to respond to that.
Well, that goes against what the defense just represented on the record, though, Your Honor. They're saying that this expert became significant after they saw the demonstrative exhibit and also realized the theme and theory of the state, which, by the way, they are not entitled to, which shows how transparent the state has been. The defense is not entitled to our theme or theory until opening statement, of course. But in Mr. Weiss's motion, he states this assertion necessitated the defense's consultation with an expert witness to address and analyze the state's claims concerning the photographs purportedly depicted. That's not true. The expert confirmed his availability to meet with the defendant on December 7th. The timeline doesn't make sense. Another note, Your Honor, the court was on the phone on Friday. The court asked Mr. Weiss if he could describe the mental condition just so that the parties could know. He says voluntary intoxication. This morning it's diminished capacity, which is not a mental condition, it's a legal conclusion. So he actually put us on notice of voluntary intoxication, which is not the mental condition. Again, unfairness. The state is now more confused. Diminished capacity because he was intoxicated, well, that's voluntary intoxication, which is not mentioned in the expert's memorandum. Again, more confusion. And let me add, Your Honor, it's not just that the state will need to, over the next 2 weeks, while General Moyle and I are proving Mr. Chen guilty to a jury of 12, it's not just that we need to secure a rebuttal expert, but we also have to subpoena records. We would be interested in all types of records of the defendant if he's claiming diminished capacity on November 23rd, 2022. We're going to be interested in new witnesses. Witnesses that maybe he was communicating with. Witnesses that may know about his capacity on or around November 23rd. This requires the state to do more. And General Moyle and I don't have time. That's the point of Rule 12.2 and every other rule that requires timely notice, Judge. That is the point. Any questions, Judge?
One thing that comes to mind, I meant to ask about earlier, on the expert report itself. court, bolded, I guess, conclusion, what he testified to. I concluded to a reasonable degree of psychological certainty that it is highly unlikely that Mr. Chen possessed the requisite premeditation to be active criminal homicide. I assume that that is the central aspect of his testimony. He'd be able to elaborate on that, but it would be that.
Yes, sir.
Okay. So, my question is that it says highly unlikely, which introduces an amount of speculation about this particular, it's not conclusive. I'm not saying the state has to agree to it, but it seems that highly unlikely is subjective, that it, cutting to the Daniel factors, I don't know whether that would be substantially helpful to try our facts, to introduce a speculative opinion that it's highly unlikely, instead of he's concluded that Mr. Chen did not possess the requisite premeditation. Could you respond to that?
Yes. I don't think it's, forensic psychology is not an exact science. We even give leeway to exact sciences. This court deals with BACs all the time, and BACs are 99.7% effective. It's not 100%. So there is no type of empirical way that a forensic psychologist can say with absolute certainty that this did or didn't happen, or this person or didn't have this mental condition. They can only base it on a number of factors. I would show the court that in the last part of the memorandum, you can see the testing that Dr. Lewis conducted, and that testing shows which are standardized testing, that shows the base raw scores from where he gets his opinion from. I think the question that the court asks is a very good question, but it's better directed towards Dr. Lewis.
Looking at this, I understand, and looking at page 6, it says a single standard score, generally being indexed and produced by a measure having a mean of 100. If I'm understanding this correctly, Mr. Chen scored a 94. It seems pretty close to the mean. I don't know how much that would have impacted his decision. Maybe it's just a test that gives everyone. The other scores, so you go test the trauma symptom inventory, looks like based upon self-report, where the person taking the test is asked how often each symptom happened in the past 6 months when Mr. Chen was incarcerated. So I'm not sure how helpful to a jury would be to have these scores from someone who's obviously been incarcerated for a long time.
I asked Dr. Lewis, that's a very interesting set of questions, but I asked Dr. Lewis about that. I said, well, wouldn't the evaluation been more, better, effective, more closer to the event than now? And he actually said, no, that's not the case. It gives, after time and reflection, and gives them an ability to answer, I guess, more honestly. But again, that's a better question directed towards Dr. Lewis. Thanks, sir.
Anything else from the state?
No, Your Honor.
For the court on this particular motion by the state to exclude the expert as the record reflects, there was an effort by Mr. Weiss to secure an expert to follow Weiss. And everyone agrees that this particular expert's testimony in this report was generated from the court's ruling about allowing a demonstrative piece of evidence. And so, looking at it in that lens, we did pick a jury, and I'll start by saying this, while we're picking a jury, none of this was mentioned, but I don't see this as unethical. I don't see it as something that Mr. Weiss waited until the last minute and orchestrated this from day one. It does feel very rushed. Again, this evaluation happened on Tuesday, less than a week ago. The state points out that they did not get the voir dire on a mental condition because they didn't know. Our Friday phone conversation involved diminished capacity. Put on record, we talked about whether it was insanity or not, and Mr. White said it wasn't insanity, so that leaves only a few things. Diminished capacity was something that was mentioned, as well as voluntary intoxication. The report doesn't mention voluntary intoxication, and again, the highly likely seems speculative to me. So I interpret all this using a greater overall analysis as it just seems very hurried, and which makes sense. It is something that the state, once they got the demonstrative evidence in, that's when we see this uptick in activity. And so I can conclude, I think fairly, that the expert's testimony was based on the defense's stated need to respond to it with this particular expert's testimony. Neither side's asking for a continuance. If this case were to be continued, it would be a huge waste of resources. But the record should reflect that I would do that. If it came down to something that truly would cause either side to not have a fair trial, I would grant a continuance in this case. I don't think that's necessary in this particular event. Again, my interpretation is that Mr. Weiss secured an expert, could be for numerous reasons. In December, when the demonstrative evidence was deemed admissible, that's when things started to coalesce in this particular direction. And so I do think that the demonstrative evidence aspect is key and foundational to why we're here today arguing about this particular expert. So the ruling from the court is that, as talked about, as discussed by defense counsel, concedes that the expert's testimony would be that it would be highly unlikely that Mr. Chen possessed directive premeditation to the act of criminal homicide. I don't see that as actually rising to the level of anything that's going to be helpful to this jury. I don't think it introduces speculation. What is highly unlikely? Perhaps he could answer that, but in contrast to the DUI experts or the engineering experts for crash reconstructions, that they have a range. They can say clearly that it happened to where the defendant's speed was within this range. It was not less than this amount or not more than this amount. With DUI, they can speculate it's at least 0.05, but not more than 0.12. In this particular case, I don't think that the expert's testimony is concrete enough to be helpful to the jury. I don't think we need to depose him for that if that's what his opinion would be. I do think that out of an abundance of precaution, the state's not going to like this part, but out of an abundance of precaution, I'm going to modify my ruling about letting the demonstrative evidence in. The ruling is that the demonstrative evidence cannot come in as an exhibit. The state can certainly use it demonstratively if they wish, to let the jury draw the conclusion. Also about the expert in the state's Dr. Cogswell. The defense has been expressed concerns that Dr. Cogswell will provide evidence that says that this was premeditated. I don't think this would have come in, but just for clarity, General, whenever you're directing Dr. Cogswell, you cannot say, is this indicative of premeditation? That's something that would have been objectionable to anyway. I'm not saying you would, but just where we are today, based on defense attorneys' assertions that the medical examiner's testimony might be unfairly utilized for him to opine that it was premeditated. Obviously, you can't ask anything about that. Okay?
Correct, Your Honor. He's a forensic pathologist, not psychiatrist, psychologist. So I think it's outside the scope of his expertise.
All right, so based on those factors, let the state's motion to exclude expert testimony be granted.
Your Honor,
Yes, sir.
at this time I would request to do a proffer and have Dr. Lewis answer some questions.
At this point, I'll let you direct the witness. Please, and swear.
Sure.
Assuming we get read out to work the first time. Well, if you're with us every Friday, you know we reference a lot. Or sometimes, and not others, have some connectivity difficulties. Here, you text Sean Johnson. You may get have a workaround between now and he gets here, but like a month's way. Works every time. Call for Sean and see what we have. Good morning, Dr. Lewis. Can you hear us okay?
I can. Good morning.
Terry, can I swear the witness for me?
Yes, Judge. Raise your right hand, sir. Do you swear or affirm to tell the truth, nothing but the truth, so help you God?
I do.
Mr. Weston. Can you let Felix know we got it figured out?
Yes, Judge.
Good morning, sir. Good morning, sir. Can you hear me?
Yes, I can.
Okay. Can you please state your name?
I am Dr. Douglas E. Lewis Jr.
And Dr. Lewis, what do you do for a living?
I am a forensic psychologist.
What is a forensic psychologist?
A forensic psychologist is a clinical psychologist who uses psychological principles to answer legal issues.
How long have you been doing that?
I have been in practice solo for about 5 years now.
To become a forensic psychologist, do you have to get an education?
Yes.
Can you
So
tell
you
me-
have to.
Go ahead.
So you have to earn a graduate degree, in particular a doctorate in psychology. And in order to do that, one must have 4 years of didactic instruction, in addition to 3,000 hours, usually minimum, in practicum experiences, which is hands-on experience under supervision. Then one must go through a match process in order to get a predoctoral internship, which is a year-long internship, and then you earn the doctorate. Once you earn the doctorate, you must participate in a postdoctoral experience, and that is for at least 1 year, and then you become licensed as a psychologist.
So what schooling did you receive?
So initially, I earned my bachelor's degree from the University of Virginia in mathematics, finance concentration in 2009. And then later, I earned a terminal master's degree of education in clinical mental health counseling from Lynchburg College, which is now referred to as University of Lynchburg, in 2013. And then in 2019, I graduated with a Doctor of Psychology in Clinical Psychology from the Chicago School of Professional Psychology in Washington, D.C. And then later, I completed a postdoctoral fellowship at Emory School of Medicine in the Department of Psychiatry and Law Service in 2020.
And when did you graduate with your doctorate?
I graduated in 2019 with my doctorate.
And you've been in practice now for the last 5 years?
Yes,
And what does your practice,
approximately.
what does your practice entail?
My practice entails both civil and criminal justice cases. So I conduct competency to stand trial evaluations, criminal responsibility or mental status at the time of the offense evaluations, violence risk assessments, psychosexual evaluations, independent medical evaluations, workers' comp evaluations, personal injury evaluations, and that's for both juveniles and adults.
Have you ever worked in the prison system before?
Yes, so I began supervised work in the prisons in 2015, and then I became someone of the de facto clinical director within a prison in 2021. Not only did I work with housing placements in terms of their psychological status, I also provided treatment in what is considered here in Georgia high max. So those are individuals who have not only committed murder or other heinous crimes outside of the prison, but also those of which who have done the same thing within the carceral environment.
Have you ever testified in a court before?
I have.
How many times?
I would say approximately 10 times. I've testified in court.
Is it just criminal cases, or do you do both criminal and civil?
It has been criminal and civil.
In the criminal cases that you have participated in, have you always represented a defendant?
No, I have not. I have been on the prosecution side before. I think the last time I was on the prosecution side was probably in 2022 or 2023.
Are you licensed in Georgia?
I am.
Are you licensed in Tennessee?
I am not licensed in Tennessee. What I got was a temporary authorization to practice psychology through the board in Tennessee.
Thank you, Dr. Lewis. I want to talk a little bit specifically more about this case involving Jason Chen. Do you remember when my
Was recognized as an expert. Would you like to be recognized as an expert?
Oh, yes, sir. At this time, the defense moves to proffer Dr.
Dr. Lewis, you said that you got your doctor of psychology in 2019. Is that correct?
That is correct.
But you were not licensed as a psychologist until 2021. Is that correct?
That is incorrect. I was licensed in August 2020.
Okay, August 2020. And then in Virginia, it was August of 2021. Is that correct?
That is correct.
All right, so licensed as a psychologist, and your degrees in clinical psychology, which is different than forensic psychology, correct?
It is the generalist form, but forensic psychology is a specialty. One must be a clinical psychologist in order to be a forensic psychologist.
So I'm sorry. Did you get a degree in forensic psychology or clinical psychology?
No such degree exists. You cannot get a doctorate in forensic psychology and practice as a forensic psychologist. You must be a clinical psychologist first, and then you must specialize in forensic psychology.
I understand. Okay. And you stated that the Chicago School of Professional Psychology is in Washington, D.C. Is that correct?
Yes, I was at the Washington, D.C. campus.
You went to school physically in Washington, D.C.?
No, I did not. So essentially what happened was I earned my degree, or I matriculated at the Georgia School of Professional Psychology in Atlanta, Georgia. While I was on predoctoral internship at the Superior Court of the District of Columbia, unfortunately, the school abruptly closed while I was on predoctoral internship. And so what happened was the American Psychological Association, in addition to the Department of Education, moved those of us who were affected by the school's abrupt closure to the Chicago School of Professional Psychology in Washington, D.C. So essentially, it was somewhat of a pro forma or formality in terms of a teach-out agreement that was reached by the Department of Education and the American Psychological Association in 2019.
You went to online school?
No, sir. Excuse me. No, ma'am. You cannot go to online school and graduate and get a license in Georgia. You must go in person. I went in person for 4 years to get my didactic instruction, and then I matched to my first choice at the Superior Court of the District of Columbia.
But on your resume, it states from 2015 to 2019, you were a psychometrist in Atlanta, Georgia.
I was. I went to school in Atlanta, Georgia, ma'am.
But your resume says that you went to the Chicago School of Professional Psychology in Washington, D.C.
Okay, so let me explain again.
I'm sorry, I'm confused. Yeah, I'm very confused.
I know, I want to help you if you allow me to, ma'am. So I matriculated at the Georgia School of Professional Psychology, which was located in Atlanta, Georgia. While going to school in person, because I come from humble beginnings, I also had to work. So I worked as a psychometrist alongside with getting my doctorate from the Georgia School of Professional Psychology. Part of the training in psychology is this. You must go to school for 4 years and receive didactic instruction and practical experiences. Then you must match at an APA or American Psychological Association accredited internship. I matched at my first choice, which was the Superior Court of the District of Columbia. While I was on predoctoral internship, which is a year-long working supervised experience, my school, the Georgia School of Professional Psychology, abruptly closed around March the 8th of 2019. The Department of Education and the American Psychological Association, understanding that we were about to graduate and the school closed, did what is called a teach-out agreement. The teach-out agreement was with the Chicago School of Professional Psychology, the Washington, D.C. campus. And that is where I graduated from.
Okay. Your resume states that you are an adjunct assistant professor at Emory University. So So the year that you received your licensing, you also became an adjunct assistant professor at Emory?
Yes,
And your LinkedIn says that you've been an adjunct assistant professor from September 2021 into present. So which one is correct?
what is correct is what's on my CV. So what happened was I graduated from the postdoctoral fellowship program in 2020. As soon as I graduated, because of my work, they wanted me to stay on to teach others. And so 2020 would be the correct date.
So September 2021 on your LinkedIn is not accurate.
If it says September 2021 on my LinkedIn, it must not be accurate. Let's go with my CV, please. That is the most up-to-date and accurate.
Okay. And a lot of your work has been with inmates, correct?
That is correct.
And a majority of your work has been, has involved a defendant's competency to stand trial, is that correct?
I wouldn't say it's the majority of my work, no. I've done a lot of work with competency to stand trial, and I also was integral in developing a jail-based competency restoration program, and I've also published on competency restoration. But I wouldn't say it's the majority of my work, no.
What is the majority of your work?
The majority of my work just includes the specialty of forensic psychology. So I do civil and criminal work, and it really just depends.
What is the majority of your work?
I wouldn't ascribe anything as being the majority other than the work of forensic psychology. So forensic psychology includes both civil and criminal work, and that is the majority of my work. It's not a particular type of evaluation or type of activity that I would say would be the majority.
Okay.
The specialty is the majority, ma'am.
Okay, and you testified that you have testified approximately 10 times in both criminal and civil court?
In totality.
10 times. And how many of those times were in criminal court or in a criminal case?
I really don't recall. I would say the majority of them were criminal. I think only 2 of them involved civil, and that was parental fitness / custody type evaluation. So I would say maybe, it was definitely the majority were criminal. I probably prepared over 100 reports for the court, and so I would say the majority would likely be criminal.
Okay, so 8 criminal cases. Of those 8, how many involved a homicide?
1.
Okay, and what did your testimony involve in that case?
I don't know if I can get into the specifics of that, but what I will say is that I was retained by the defense on that case.
Was your testimony regarding the defendant's competency to stand trial?
Oh, no. My testimony was regarding mitigation for sentencing.
So you testified at a sentencing hearing?
Yes.
And you understand that there's a difference between testifying and being tendered as an expert witness and qualified by a court as an expert witness, correct?
In the state of Virginia, where I testified for this particular case, I was voir dire.
How many times have you been qualified by a court as an expert witness?
I would say approximately 10 times.
Where,
Each time that I testified, I had to be voir dire by both sides.
I'm not asking about voir dire, I'm asking about tendered and qualified as an expert witness in a case. Qualified as an expert witness.
If I'm understanding it correctly, approximately 10 times.
You testified that you often do evaluations on mental state at the time of the offense.
Yes. So it's called different things based on the state. So in Georgia, it would be called criminal responsibility. In Virginia, it would be called an insanity evaluation. So I just generally said, but both of them are the same in that it is assessing or evaluating one's mental status at their time of the offense.
You believe that insanity is the same as mental culpability?
No, I don't think I said that, ma'am. What I was saying is that the statute is named differently based on the state. So some would call them mental status at the time of the offense. Georgia, for example, calls it criminal responsibility, and Virginia would call it insanity. But it's state dependent, and the state determines what the legal standing is for that.
Okay. On your resume, there's a section entitled Adult-Clinical. And it states that in 2011 and 2012, you were, it doesn't say what your position was, it just says adult psychiatry / co-occurring disorders inpatient at Virginia Baptist Hospital.
That is correct.
But in 2011 and 2012, the only degree that you had was in mathematics.
That is correct.
Virginia Baptist Hospital was allowing you to work in a psychiatry department with a mathematics degree?
Yes, ma'am. So in Virginia, there is a title called Qualified Mental Health Professional, or QMHP. And as long as you have a bachelor's degree and you take the continuing education, they will give you a certification called a Qualified Mental Health Professional. And so that's what I became, and that's how I was able to work at Virginia Baptist. I also interned at Virginia Baptist under the supervision of a clinical psychologist while I was earning my terminal master's degree in clinical mental health counseling from what is now called the University of Lynchburg.
One moment, Your Honor. What is a psychometrist?
A psychometrist is essentially an individual who has at least a master's degree, who has been trained to conduct psychological assessments, or which involves administration, interpreting, and scoring, and that individual must be supervised by a psychologist.
And your resume states that you were a psychometrist from 2015 to 2019, is that correct?
Yes.
And this is while
And
you
in
were,
that role,
what?
in that role from 2018 to 2019, I took on I was a reviewing psychometrist, which is a little bit different from actually administering the scores or administering the measures. So from 2015 to 2018, I was in person actually administering the psychological test, scoring and interpreting and writing reports. From 2018 to 2019 as a psychometrist, they had me review other psychometrist reports for their accuracy and then send them to the psychologist.
Okay. And let's turn to your teaching experience. From 2016 to 2018, you have two separate places in your teaching experience. It says that you were a teaching assistant with the Georgia School of Professional Psychology. What are the differences between those two? Why is that listed twice on your resume?
Because I was a teaching assistant for multiple professors. and my graduate program.
And you were
Statistics,
also a psychometrist at that time.
yes, ma'am.
You were also working in Buford, Georgia in that time.
That was as an intern, but yes, ma'am.
And you were also in College Park.
Yes, ma'am.
Let's turn towards this case. What were you asked to do in the case of State versus Jason Chen?
I was asked to assess or evaluate the issue of premeditation.
When were you asked to do that?
December the 10th is when I was asked to do that, of 2024.
When was your first communication with defense counsel in this case?
It was late evening, December 7th of 2024.
And you said that you were asked about premeditation. What does that mean?
Premeditation as defined by the state of Tennessee.
As it relates to Jason Chen?
Yes.
What is the offense date in this case?
I don't recall the exact offense date. I do recall that it was in 2022.
Okay.
I believe it was November of 2022.
And were you asked to evaluate the defendant for mental condition?
Yes, I suppose that was a part of it, yes.
What were the other parts of it?
Well, the only thing that I was asked was about the issue of premeditation, but of course, if I'm conducting a psychological evaluation, there is a possibility that a mental condition could emerge or be revealed. But my understanding, my understanding was that that individual had never had any mental condition. But part of a psychological evaluation, such could be revealed.
Did you decide that Mr. Chen has a mental condition?
I did not give Mr. Chen a formal diagnosis. However, Mr. Chen does have some, what I would call some mental health or psychiatric challenges, to include depression and anxiety.
Dr. Lewis, I'm sorry to interrupt. The technical transmission of what you said a moment ago didn't completely come through. I think I understand what you said, to make sure you say you did not give him a formal diagnosis.
That is correct. So I did not give Mr. Chen a formal diagnosis. However, I do know that he has some psychiatric or mental health challenges.
How do you know that?
Depression and anxiety. Based on psychological testing, based on my interview with him, and my observations of him.
When you say psychological testing, are you referring to the tests that are mentioned at the end of your memorandum?
Yes, ma'am.
Okay. And are you aware of how long Mr. Chen's been in the Hamilton County Jail?
Approximately, since his arrest, I would say approximately 2.5 years.
And are you able to opine as to when he developed his depression and anxiety?
My opinion is that he developed it during childhood.
So I'm assuming that you had reviewed his medical records from childhood forward.
I reviewed what was in the discovery, and in the discovery, I did not see any medical records.
I'm assuming that you interviewed
Mr. Chen.
his parents to learn more about his childhood.
I reviewed the statements that were in the discovery from his parent, particularly his mother. But other than that, no, I did not interview his parents.
The statements from his mother that included that he did not have a mental condition?
Yes. I saw that in the discovery, multiple times individuals indicated that he did not have a mental condition. I disagree.
Because Jason told you that he did.
No, he actually did not. He said he doesn't have any problems either.
So what did you rely on? You had no medical records. You did not interview his mother and father when it comes to childhood issues. The defendant denies having any kind of mental condition. What did you rely on?
I relied on my years of experience since 2010 of working in the mental health field across jurisdictions. I also relied upon my review of the discovery, all the documentation that was in there. I relied upon my interview with Mr. Chen, which involved many questions, to include questions that are diagnostic, questions that deal with violence risk, questions that are about his sexual history. I also relied upon objective, tested, psychological testing that is peer reviewed, and all the other things that were in discovery. And that is what I relied upon, which is best practices in terms of the field of forensic psychology. It was a multi-method approach.
You've only spent 3.5 hours with Mr. Chen.
Approximately 3.75 hours.
Oh,
yes.
I apologize. You've only spent 3.75 hours with Mr. Chen in Mr. Chen's entire life.
That is correct.
And that was last week.
January the 2nd.
And you administered 3 tests during that 3.75 hours?
Yes, and that took him about 50 minutes or so to do, the 3 tests.
50 minutes. He did 3 tests in 50 minutes?
Yes, one of them you have to finish within 16 minutes for it because it cuts off on you. So one of them was time.
So, and then the rest of the 3 hours, you just simply asked him questions about his mental condition that he doesn't have?
No. I asked him questions basically about his life from birth to present. So those questions are across the board. Some of which of the questions you don't really know, or the individual or the examinee really doesn't know why I'm asking the questions that I'm asking. They're not face valid. So the questioning is not just about a mental condition.
You based your opinion that it's highly unlikely that Mr. Chen could form premeditation in 2022 based on 3.75 hours with Mr. Chen. 50 minutes of those were consisted of him taking 3 tests to help you decide this issue.
And also over 14 years of experience of working with justice-involved persons.
And one of those cases in 14 years involved a homicide.
No, many of them did. Only one of them I testified for, but I've done many murder cases that I've written for. Usually the court stipulates to my reports. So I don't testify a lot.
Well, but
for
your
that
reports
reason.
don't
But
have your reports don't have to do with premeditation at the time of the offense.
But they have to do with murder, which is what you asked, I thought.
Okay. None of your reports have had to do with premeditation at the time of an offense.
No.
And in your memorandum to the court, did you mention depression or anxiety?
I don't believe that I did say that. I don't believe I said that explicitly. However, if you look at the end where the tables for the testing, even a layperson can see that some of the scales are elevated regarding depression and anxiety. But no, I don't think I explicitly indicated that in the memorandum.
Have you ever been in jail, Dr. Lewis?
As a professional, yes, I've been in many jails and prisons.
Of the people that you've worked with, how many of them experience depression and anxiety?
Probably most of them.
You stated in your memorandum that you relied on a handful of articles or websites in one case, a book to form your conclusion in the case of Jason Chen, is that correct?
Relied on is probably not the right language. I would say that those items, in addition to all the other methods, is how I form my opinion. So essentially, I provided those for individuals who are not versed in mental health or forensic psychology, etc. But yes, those were a part of forming my opinion because it gives foundation of knowledge for those who are not privy or not in this area.
Sure, your report says, and a review of pertinent research, and then it cites to footnotes 5 through 15, is that correct?
That's right, ma'am.
And number 5, the title is Proactive and Reactive Aggression, a Developmental Perspective. Are you going to opine about Mr. Chen's aggressive behavior?
I intend to educate the court about, some people call it in literature proactive and reactive aggression, and then in some literature it's called affective and predatory aggression or violence. And so what I want to do is educate the court about the difference between affective or reactive aggression versus predatory or proactive aggression.
And what does that have to do with Mr. Chen's mental state on November 23rd, 2022?
Well, what that has to do with it is that in terms of premeditation, typically one shows that they have predatory or proactive violence or aggression. And there are certain items that must be there, or factors or traits that must be there for such. And when in issues that are raised about premeditation where someone's arguing that an individual doesn't have premeditation, then one would look at affective or reactive aggression, because those have certain elements or traits. And so what I would like to do is, what I intend to do is to educate the court on the differences of the two.
You understand in this case you would not be testifying to the court, right?
We're not testifying to the court. I'm saying educating the court about the difference, because the differences of those two items goes into my opinion about the issue of premeditation.
How do those issues relate to diminished capacity?
They don't relate to diminished capacity.
But that's what your finding is from Mr. Chen.
I didn't say anything about diminished capacity. I didn't use those terms. My understanding is that that is not a term that's in Tennessee, but that it is recognized in Tennessee, but I'm not using those terms. What I'm saying about Mr. Chen has to do with affective or reactive aggression, as well as the impact of substance use. However, I'm not explicitly using those terms, or that term.
So, what is your finding as to Jason Chen's mental condition on November 23rd, 2022?
My finding is that Jason Chen likely displayed affective aggression while also under the influence of substances.
And what evidence or information do you have that Mr. Chen was under any type of influence of substances on November 23rd, 2022?
In terms of evidence, the only thing that I have is that his report that he was using substances, and also by my questioning of him, many of which were not face valid at all, it appears that he has been using substance for many years.
You'd agree that using substances for many years doesn't mean that you were intoxicated on November 23rd, 2022, right?
I do agree with that. However, in my work with substance users and individuals that are just as involved, people just don't stop using substances.
So you are going to testify that Mr. Chen was under the influence of a substance on November 23rd, 2022 because Mr. Chen said he was?
I'm not going to testify directly in that way. What I'm testifying to is that he reported that he was under the use of substances. And the psychological testing suggests that he does have issues with drugs.
So you
So
can't.
I'm not directly reporting that. I'm reporting that that's what he informed me of. And based on his psychological testing, it suggests that he does have issues or challenges with drug use.
Well, you said you'd gone through discovery in this case, correct?
Yeah.
When did you receive discovery in this case?
It had to have been the week of December 17th, because it wasn't until December 17th that the Tennessee board allowed me to have temporary authorization to conduct the evaluation.
So, homicide cases involve an extreme amount of evidence, correct?
Yes, they do.
And between December 17th and January 7th, would you say that you went through all of the discovery that was delivered to you by the defense attorney?
Between then and January 7th, I would say no. I went through most of it, and since that time, I haven't gone through all of it.
What did they deliver to you?
There were pleadings, there were mitigation documents, there were police reports, there was a medical examiner's report, there were pictures of the deceased, there were pictures of Mr. Chen and his family, there was a transcript of his bond hearing back in, I believe, back in 2022. There was a lot.
And what in that discovery indicated that Mr. Chen was under the influence of a substance on November 23rd, 2022?
I don't believe anything explicitly indicated that.
And what was that substance?
He reported that he and the deceased drank an entire bottle of wine, and after they drank an entire bottle of wine, they smoked joints or marijuana, and then they also had wax, which is concentrated THC.
But you'd agree based on the autopsy report that there's evidence to the contrary of that, correct?
Objection to argument.
I think that the question was specifically to reports, or I guess the toxicology report and the medical examiner's findings. So at this point, I don't think it's argumentative.
You'd agree that based on the autopsy report, there's evidence to the contrary. Is that correct, Dr. Lewis?
I would agree, but I think that the question you're asking is a bit misleading, given when the body was found and given how the testing was done. Apparently, based on what I saw, it looked like the testing was stopped for some reason. And then also because there had been some time that had passed, and the way that any type of drug enters your body, there's a time where it has a half-life. So it starts to diminish or denature. So I don't think that that is I don't think that that is a clear question. I would say that yes, the medical examiner said that there was nothing found in terms of substance use, but I don't think I think that question is a bit misleading.
And Dr. Lewis, you don't have a degree in forensic pathology, do you?
I don't, but I know what I've read.
And you don't have a degree in pharmacology, do you?
I don't. However, when you are trained to be a clinical ophthalmologist, you do have to take psychopharmacology. So I had to learn about pharmacokinetics in terms of medication.
And you can't, as a psychologist, prescribe medication, can you?
I cannot, the psychologists do. They do additional
Okay,
training.
well, I'm not concerned about other psychologists. You can't prescribe medication, can you, sir?
That is correct.
And your basis of knowledge pertaining to marijuana, based on your memorandum, is one of them is from the DEA website.
The DEA website is good information for laypersons, but I have treated and worked with people who have substance use disorders. So again, what was on the memorandum was for people like you and others who are not trained in working with substance use disorders or psychopathology, and that was for a reference that would be easy for you all to understand. However, I am not solely basing my opinion on the 15 citations that I gave. I'm basing my opinion on years of working with individuals in different jurisdictions who have substance use disorders and also have mental disorders.
But in your memorandum, you'd agree that you referenced these specific articles as what you reviewed to help you form your conclusion in this case.
I said that those articles were useful in forming an opinion. However, they are not the only things that I use. Part of being an expert is that it's the years of working with individuals who have similar or the same types of challenges. So I would not hinge my opinion on just 15 citations. It's more so to allow the reader to understand what it is that I'm talking about. So I don't want to be misleading and have you think that only 15 citations, one of which was a DEA website, is how I came up with my opinion. It's actually my years of training and in practice with individuals.
And which of these articles have to do your resume has a lengthy list of publications that you, along with others, have published over the years. The last publication being in 2022. Presentations that you gave relate to the defendant's mental state at the time of an offense?
None of them.
How many times have you testified to a defendant's mental state And in that case, did you interview the defendant?
Yes,
For how long?
about an hour.
How far was that interview from the time of the offense? How long after?
I would say approximately maybe like 10 or 11 months after.
And what was your opinion in that case?
My opinion was that he was sane, or he knew what he was doing. So I was on the side of the prosecution.
So that had to do with sanity, is that correct?
Well, in the state of Georgia, it's called criminal responsibility. So I found that he was criminally responsible.
Well, you just said sane. So is it sanity or criminal responsibility?
It's criminal responsibility. The case was in Georgia.
What type of homicide was that?
It was not a homicide. It was an aggravated assault.
So you've never testified or opined regarding a defendant's ability to form premeditation in a homicide case.
I've written reports that I have opined that they were criminally responsible of a homicide. But I've never testified. But I have written reports in murder cases where I found them criminally responsible for the murder.
A report for what? I don't understand. For sentencing?
No. So there's two types of reports that are common in courts. One type is called competency to stand trial, and the other type is called, based on the state, it would be either criminal responsibility or insanity evaluation. Those reports, those types of evaluations are ordered more than any other type of evaluation. And so often, I would perform a competency to stand trial evaluation as well as a criminal responsibility evaluation. So these things happen pre-adjudication. They're not sentencing or mitigation.
Where do those reports go?
Okay, so the competency to stand trial evaluations typically go to the court. Now, the criminal responsibility evaluations go to the defense typically, because that's usually more of an ex parte issue. And when it comes to sanity or criminal responsibility, essentially people see it as a legal strategy at times, because it depends on how the attorney wants to work through the case. So those types of reports only go to the defense attorney typically, because the individual is admitting that they committed the crime, and I am evaluating their thoughts or actions or behaviors before the crime, during the crime, and after the crime. And for that reason, typically those reports do not go to anyone but the defense attorney, who decides how they want to work the case.
They're never intended to be introduced in a trial or in a hearing for the defendant's guilt, right?
I can't say that because I'm not an attorney. I'm not sure how they use it afterwards.
Well, where is that report in this case?
Pardon me?
Where is that report in this case?
Those type of reports are ordered by the actual judge. So if it's not ordered by the judge, then there is no report. I was retained by the defense, and when the defense or the prosecution, whoever retains me, they ask a question, and I'm the one who is evaluating the question that they're posing. But those type of reports are typically ordered by a judge.
What was the question in this case?
The question in this case was to, again, evaluate or assess the issue of premeditation.
That's not a question. What was the question in this case?
That was the question.
To evaluate premeditation is not a question.
Okay. Determine whether or not Mr. Chen had premeditation in this particular case. I'm not sure how you want me to word it.
Okay.
That's what I was asked to evaluate.
Okay. Let's go to the tests that you administered in the 50-minute time period you met with Mr. Chen in the Davidson County Jail. TOGRA is intended to measure reasoning and critical thinking, is that correct?
Yes, ma'am.
And Mr. Chen, with a 94, was within the standard deviation, correct?
Yes, ma'am.
And you'd agree that school records probably also could indicate someone's level of reasoning and critical thinking, is that right?
They could. However, there can be a little bit of politics when it comes to school records, like individual education programs or 504 plans. Sometimes individuals can be labeled or mislabeled depending on their behaviors in school. And so I would not use school records as the only standard in making an opinion.
So did you
Particularly
review,
when I work.
did you review Mr. Chen's college transcripts?
No, I did not.
Are you aware that he had a scholarship to the University of Tennessee at Chattanooga?
Yes, and I actually asked how did that happen, given some of the information that I learned about his, some of his own reports about his behavior in school. I was curious about that he did earn a scholarship, but different scholarships have different requirements. So I know that scholarship that I'm aware of, he likely wouldn't have been necessarily a person that would have gotten some of the scholarships I know about. However, yes, he did report that he had gotten scholarships in school.
What does reasoning and critical thinking have to do with affective aggression?
Well, I don't think the two are directly related. However, one must have a certain level of reasoning and critical thinking ability to be responsible, knowing, or intelligent. One must have those attributes. So part of the reason why I did that testing was to get an idea of how he's functioning cognitively, and he's functioning in the average range in terms of when compared to other adults. So that's why I gave that test.
Okay, and did this test measure how he was functioning cognitively on November 23rd, 2022?
No, ma'am. However, I will say that intelligence cognitive functioning tends to be stable unless something happens like a traumatic brain injury or some type of other injury. Typically, intelligence or functioning is stable, particularly at a certain age group in the lifespan.
I understand. So if he was functioning cognitively in January of 2025, he most likely was functioning cognitively in November of 2022 based on what you just said.
Yes, in the absence of substances, absolutely.
And personality assessment inventory. Which one of these tests takes 16 minutes?
The TOGRA.
And then how long do the other two tests take?
It depends. Some people have gotten it done in 20 or 25 minutes, and then some people have taken hours to do it. It just depends.
How long?
It's basically questions that says it's mostly true, slightly true, false, never. So it's things like that. So the items are short. Like some of the items might say something as short as I like airplanes. It's not much. You don't have to do much thinking. It either is or isn't. So it depends though. Often people who take a long time are people who are misleading, and they typically invalidate the test because they're thinking too much.
So in 50 minutes, you're comfortable with a criminal defendant charged with first-degree premeditated murder taking a test of general reasoning ability called TOGRA, a traumatic symptom inventory, and a personality assessment inventory?
I I was with him for longer than 50 minutes.
No, that was my
I said it
question.
took okay.
Are you comfortable?
Could you rephrase?
Are you comfortable with a defendant taking 3 psychological tests within a 50-minute period that you then rely on?
That was part of a multi-method approach? Yes. I would not rely just on that, no. So I think you already mentioned all the things that I did rely upon. But just the testing, no. So it's best practices that you do a multi-method approach. So I would never hinge an opinion just on testing. It's everything, and it's everything that I review.
For the trauma symptom inventory, TSI-2, it says that the clinical scales reflect 4 broad categories of distress: self-disturbance, post-traumatic stress, externalization, and somatization.
Somatization, yes.
Can you explain which of those has to do with the defendant's mental state at the time of an offense?
So that particular testing doesn't mark directly to a mental status at the time of the offense. What it does is it gives me a profile of how this person is social emotional function. So does this person lash out at others? Do they have anxiety? Do they have depression? Have they experienced trauma in their lives? Are they likely to become easily angered or agitated? So what that does is it's one component of gives me an idea of his personality profile, but it does not. There is not a test that loads directly onto a legal issue. That's not how testing is designed.
Okay. And so the same thing for the personality assessment inventory. That test has nothing to do with the defendant's mental state at the time of the criminal offense, does it?
Not directly, no.
Do any of these have to do with substance disorders?
Yes.
And do they have to do with a defendant's use of a substance 2 years prior to the test being given?
So typically, what it does is ask innocuous questions that essentially we're recreating a personality profile. While individuals are different, there are certain challenges that people have that are very similar. So what we've developed through the testing is we are developing a personality profile panoramic of how someone is functioning. So no, it does not necessarily is not as specific as you're asking. However, when I talk about likelihood, there's a certain personality profile that is developed by use of the testing and the other sources.
Council approach with us. Thank you, gentlemen.
Since you reviewed the discovery in this case, Dr. Lewis, can you describe some of the things that the defendant did after he murdered Jasmine Pace?
He visited a convenience store.
Objection. I don't know the relevancy regarding his qualifications. I don't know how that question answers. This is for here.
It seems like it could apply to both, I guess, in the sense that's clearly relevant to his opinion. may be relevant to his qualifications. He gives great weight to it, not much weight to it. So at this point, feel free to renew your objection otherwise anytime it gets raised too far. Okay. Yes.
Okay, continue, Dr. Lewis.
He went to go purchase cleaning products.
And what else?
He also moved the victim's vehicle. He used the cleaning products to clean up his apartment.
And what else?
He left the apartment, I believe, to stay with his parents.
And what else?
I'm not sure what else you're asking me.
How much weight do you give to what a defendant does after a murder when it comes to premeditation?
When it comes to premeditation, I give it great weight. I find those details, quite frankly, to be aggravating.
What do you mean?
What I mean is that essentially, if those things, or if those actions are the actions he took, then it appears that he attempted to hide or cover up whatever act that he committed. So I take great weight to that. I found that aggravating. However, I do not find that it is suggestive of premeditation. Quite frankly, I find it to be the opposite in terms of the individuals that I work with inside the carceral environment. If they engage in forethought or planning, they typically would not do the actions in the way that it was reported that Mr. Chen did. It doesn't fit the profile of someone who engaged in forethought and planning.
But in Tennessee, premeditation doesn't require planning, right, Dr. Lewis?
Based on what I read in terms of premeditation, it means that you have to have some type of forethought before the action is done.
You'd agree that somebody who is under the influence of a substance would have, how would you say it? Well, a difficulty completing tasks that a sober person may be able to complete, correct?
They probably wouldn't be able to do it in the exact same way. But someone who's been doing substances for quite some time, they may be able to function a little bit better than someone who perhaps is just starting a substance.
So if Mr. Chen was a regular marijuana user, he probably could have functioned a lot better if he was under the influence of that substance?
He may have been able to. However, he also said that he used wax, which wax is a much greater concentration of marijuana, or THC.
Do you take into consideration when forming your opinion that criminal defendants will most likely say whatever they need to say instead of going to prison for the rest of their life?
Absolutely.
How is that factored into your decision here?
I didn't give great weight to it. It is part of the decision, but I didn't give great weight to the use of the substance. I gave more weight to the personality profile type that he fits into, more so than the use of a substance. He did report that he used a substance. The testing shows that he's likely a substance abuser. However, that is not something that I gave great weight to.
You did not give great weight to the use of a substance.
Great weight? No. It is a part of it. But I did not give great weight to it because, as you mentioned, he reported that he used a substance. But that's not something where I'm hinging my decision solely on substance use.
What did you give great weight to?
What I gave great weight to was the personality profile type that he fits. For example, my understanding is that the one theory is that he planned, or he planned this murder because the victim was bound. So if you understand, or if you work with individuals who have a psychopathic or psychopathic personality, or who are a sociopath, you will learn that the details, as is mentioned in the theory that's been presented, is not, it is not consistent with the, it's not consistent with the evidence. Someone who would conduct an act of that sort, they build gradually. You don't just start out a murder in that type, or murdering or harming others in that type of way. That is a gradual type of violence or aggression. So what I was looking at his personality profile type, and then I also was looking at the different theories that were presented. And so what I'm saying is that we would expect to see other things within his personality profile type. There should be other violence or aggression. There should be other charges of violence and aggression. There should be a history there should be a known history of maybe intimate partner violence. There's a lot of things that should be within the personality profile type and within the evidence, given the theory that's been presented, that's not there.
How many of Mr. Chen's former girlfriends did you speak with?
None.
How many of Mr. Chen's friends did you speak with?
None.
How many of Mr. Chen's family members did you interview?
None. I reviewed what was written in the discovery.
So you're basing your knowledge on Mr. Chen's prior violent history on what Mr. Chen told you?
And I'm also looking at the legal record. Did you produce some charges for Mr. Chen in terms of violence and aggression? Because typically that's what those individuals like that's what they have at a much younger age than now. They start at 10, 11, or 12 years old.
Hang on just a second, Joe. You approached here. Christian. We're letting the jurors go downstairs to stretch their legs, and I don't want them to walk by and hear anything. So we can just a minute to do that.
Yes, Your Honor.
We can proceed.
Yes, sir.
Dr. Lewis, you can just hang out for just a moment. We've got to take a pause, and then we'll resume as soon as we can.